My name is Heather Wokusch, and welcome to another segment of Leaving the Nuclear Age. Today we are here with Dr. John Burroughs, who is the Executive Director of the Lawyers Committee on Nuclear Policy. Thank you so much for joining us.
I'm glad to be here.
Can you give us a little bit of background on yourself and what you do?
I started being Executive Director of Lawyers Committee on Nuclear Policy in 1999. It's based here in New York City, right next to the United Nations, and a lot of our work is there. So it's been a lot of research, writing, speaking, advocacy at the UN, in the Nuclear Non-Proliferation Treaty, and right now we're engaged in working with the Marshall Islands on nuclear disarmament lawsuits in the International Court of Justice. Before I came to Lawyers Committee on Nuclear Policy, I was a consumer lawyer in California, but I also worked with an organization, Western States Legal Foundation, that was monitoring and challenging the Livermore Nuclear Weapons Laboratory. I was involved in nuclear weapons protests. I defended nuclear weapons protesters. I wrote a PhD dissertation about international law on nuclear weapons.
So how did you get involved in the whole area of nuclear weapons?
I was really aware of it as a child, and then in college, and in the late 1970s, I was working with a kind of alternative newspaper in Seattle, Washington. It's called the Northwest Passage. We were covering nuclear weapons quite a bit. Trident Nuclear Submarine is based in Washington State. I was involved in a protest. Was arrested at a protest at the Trident nuclear base in Bangor, Washington. And we defended the action on the grounds of international law, and I thought, boy, this really makes sense. And so that's how this all got launched.
Well, when you look at today's legal environment in relation to nuclear weapons, what do you see?
I see some pretty good law that should be guiding the world and the nuclear weapon states towards disarmament, but that is being essentially disregarded. The Nuclear Non-Proliferation Treaty is the treaty that prohibits the acquisition of nuclear weapons by most of the world. Maybe people don't realize that the Nuclear Non-Proliferation Treaty was the basis on which a deal was struck with Iran to hopefully ensure that its nuclear program remains peaceful, as they say. In other words, that they don't acquire nuclear weapons. But the NPT, the Non-Proliferation Treaty, also contains a requirement that all states, but especially the nuclear weapon states, pursue negotiations in good faith on effective measures relating to nuclear disarmament.
Article 6.
Article 6. So it requires the world, and especially the nuclear weapon states, to negotiate the elimination of nuclear weapons. However, what we're seeing is a very muddy, stalemated process dating back to the last significant step, that was the negotiation of the Comprehensive Nuclear Test Ban Treaty in 1996, which prohibits all nuclear weapons test explosions. Since then, there have been modest agreements between the US and Russia on reducing their two arsenals, but in terms of global treaties that set the world on a path toward the elimination of nuclear arsenals, we're not seeing that. The United States government says that it's pursuing a so-called step-by-step path to a nuclear weapons-free world. So they say they're trying to negotiate a treaty that would prohibit the production of fissile materials for nuclear weapons. That would have been a great thing back in the 1950s or 1960s. It would have cut off the nuclear arms race. Today, though, if you're just stopping production of fissile materials for weapons, plutonium, and highly enriched uranium, in the future, you're not really coming to grips with the problem, which is the reduction and elimination of existing arsenals. So most of the world, and certainly my organization and many nonprofit public interest groups around the world, NGOs, say that it's time now for there to be multilateral negotiations on nuclear disarmament. And our position is that that would be compliance with the disarmament obligation contained in Article 6 of the Non-Proliferation Treaty.
So there are many different legal areas to go for. You can go for fissile materials, as you said. You can go for testing. You can go for high alert. You can go for the delegitimization of nuclear weapons. Where do you see as a good place to start? What are some of the models?
One thing we've seen in the last 5 years has been a rather energetic movement to point out the consequences of nuclear explosions and to explain that if you have a nuclear explosion in an urban area or several of them, there's really no adequate response to that, medical and emergency care and so on. There were conferences in Oslo, Nayarit, Mexico, and Vienna in 2013 and 2014. And the approach has been one of saying we don't want to talk about nuclear weapons in terms of so-called deterrence, in terms of international stability, in terms of national security. We want to talk about what these devices do. They explode and they hurt people, and the consequences can't be adequately responded to. So if you want to put labels on that, it's stigmatization, it's delegitimation. Now this isn't new. There have been criticisms of nuclear weapons right from the beginning of the nuclear age, when John Hersey wrote in the New Yorker about what the damage to people and the environment was of the bombings of Hiroshima and Nagasaki. But it's been revitalized. This critique has been revitalized in the last few years. And along with that, there's been an increased emphasis on the importance of international law. Both the fact that there's international law that regulates the conduct of warfare. Americans are certainly familiar with the idea that in military operations, you're not supposed to target civilians, and the so-called collateral damage from military operations is not supposed to be excessive, right? We see that in the newspaper all the time. Well, those rules and others like that, the prohibition of indiscriminate attack, are just completely and utterly incompatible with the use of nuclear weapons. So there's been a revived critique of the illegality of the threat and use of nuclear weapons, and the Red Cross and Red Crescent movement has stepped in. And we've been doing our part, because this is a major part of our message, is to say these weapons just cannot be used in compliance with international law. And of course, it would be an atrocity to use them. So what's the importance of talking about international law? Well, one important thing about it is that governments maintain that they do comply with international law. So you're challenging them on something that is quite important to the way that they operate.
One challenge is that Article 6 is rather vague. And another issue, for example, you mentioned the humanitarian conference in Vienna that built up so much momentum, and everybody was quite excited going into the NPT in New York, which was not so. The result was basically stasis. I mean, many people saw it that way. And so I guess the question is, how can the pressure be kept up on governments on a legal basis, given that the actual, for example, Article 6 doesn't really delineate very clearly what they have to do?
Well, I'm going to disagree with you on your last point.
Okay.
But let me first start out by saying you're right that the Vienna Conference on Humanitarian Impacts, sponsored by the government of Austria, was held in December of 2014. 150 countries attended it. dozens of non-governmental organizations, and the energy from that spilled over into the 5-year review governmental meeting to review the operation of the Non-Proliferation Treaty and to look forward. By the time of that conference, over 100 countries, by the end of it, had signed a pledge put forward by Austria saying that they will support all efforts to negotiate effective legal measures to prohibit and eliminate nuclear weapons. The conference seemed about ready to agree on a final document, but there was a sticking point, and that was an agreement on how exactly to hold a conference on advancing a process towards a Middle East free of nuclear, biological, and chemical weapons. Weapons of mass destruction, they're called. So the conference failed to reach agreement because of that disagreement, which has to do partly with Israel, or largely with Israel. Israel is not a party to the NPT, so it's a very odd and complicated situation.
Right.
So the review conference did not agree on a final document. And many followers of the NPT saw this as a huge disappointment, failure, setback, so on.
But you didn't.
Not particularly.
Okay.
And here's the reason. Some very strong commitments have been adopted at past NPT review conferences. 2000, 1995, 2010. Commitments like an unequivocal undertaking to eliminate nuclear arsenals. Pretty clear, right? Diminishing role for nuclear weapons in security policies. Reduction and eventual elimination of nuclear arsenals, and so on. Those commitments largely have not been fulfilled, but they are still valid. They are still benchmarks for assessing performance of the nuclear armed states under the NPT. It gets a little bit absurd to have review conferences adopt commitments that are not then observed.
Yeah.
And that's why I didn't view it as a particularly bad thing that it wasn't done again this year.
Well, I guess one thinks, enough is enough. When can we move on? Now, there have been some interesting activities regarding the Marshall Islands saying enough is enough.
That's correct. Right. I was mentioning earlier that along with the humanitarian consequences movement of the last few years, there's also been increased emphasis on law, international humanitarian law governing conduct of warfare. But the Marshall Islands brought to the fore another aspect of the law which we've already referred to, and that is Article 6, the nuclear disarmament obligation. And the Marshall Islands brought cases against all 9 countries that possess nuclear arms. Can you name them? I will name them. U.S., UK, France, Russia, China, India, Pakistan, Israel, North Korea. Brought cases against all 9 countries. I have the privilege, and it really is a privilege, of being on the international legal team. And we prepared really terrific applications, and those cases are underway. Now, why would the Marshall Islands do this? Marshall Islands, after World War II, became a trust of the United Nations, and it was put under the guardianship of the United States. So while the Marshall Islands was a trust territory of the United Nations, the United States conducted 67 atmospheric nuclear explosions in those islands. One of the largest ones was the Castle Bravo test in 1954, 15 megatons, 1,000 times the size of Hiroshima and Nagasaki. Tony DeBruym, the current foreign minister of the Marshall Islands, as a 9-year-old boy, saw that explosion. So the Marshallese are coping with the consequences, the health and environmental consequences of those tests to this day. And the compensation provided by the United States has been really, really inadequate. In the 1980s, the Marshall Islands became an independent country and joined the Non-Proliferation Treaty in 1995. So it brought the cases at the International Court of Justice on the theory that you also hear from the survivors of the bombings of the Japanese cities of Hiroshima and Nagasaki, the Hibakusha. The Hibakusha say never again. Well, the Marshallese were also saying, we suffered these atrocities, we don't want to see anybody else suffer them. Well, the cases in the International Court of Justice are not about compensation. They're about compliance with the nuclear disarmament obligation under Article 6.
And what could be the result of this case?
Let me tell you just a little more about it. So it turns out, well, we knew this going in, but only 3 of the countries have accepted the compulsory jurisdiction, it's called, of the International Court of Justice. And so cases are proceeding against those three countries: United Kingdom, India, and Pakistan. And the other 6 countries, including the United States, the Marshall Islands, invited them to come before the court voluntarily under a standard procedure. But, not to our surprise, they have declined to do so. You said earlier, with, some reason, that Article 6 is vague. It says, pursue negotiations in good faith on effective measures relating to nuclear disarmament. But over the years, in NPT review conferences, its meaning has been sharpened. The unequivocal undertaking to eliminate nuclear arsenals, the principles of verification, irreversibility, transparency, diminishing role of nuclear weapons in security policies. So the Marshall Islands' position is that it is clear now what Article 6 requires, and it requires an end to modernization of nuclear arsenals because that's contrary to good faith. How can you negotiate in good faith the elimination of nuclear arsenals while you are at the same time planning and spending for maintenance and modernization of nuclear arsenals over decades? And the Marshall Islands is saying it's now time, it has been time for quite some time, for the commencement of multilateral negotiations on nuclear disarmament. So if the court gives a judgment, and I say if because the court still has to decide, there will be hearings next spring on this question, whether the cases are suitable for adjudication on the merits. But if the court gets to the merits, which I'm sorry to say, would still be some time from now, maybe a couple years from now, then the Marshall Islands is requesting a judgment that the defendants are in violation of their nuclear disarmament obligations, which in and of itself would require them to come into compliance with those obligations, and in order saying that they must do so within a year. Now it's just those 3 countries, but rulings really would amount to authoritative statements of the law, which would apply to other states as well.
Which is wonderful, and it's amazing that you have initiated this. I mean, it's a very, very important case. Meanwhile, however, if I may play devil's advocate, you've got something like $100 billion coming out of a slush fund to update the 12 Tridents, into, even newer and improved nuclear weapons systems. And right now Russia is, radically also updating its own systems. It seems to be the time to do that. So is there any kind of legal basis possible, either regarding, testing or fissile materials or high alert or delegitimization, that could be done in addition to fighting, for example, in the International Court of Justice?
Well, I think the International Court of Justice is really sort of the main strictly legal avenue. But in the United Nations and the non-proliferation treaty, for that matter, in governments around the world, the policy and the legal arguments mix together. In obviously, I think the legal part of it is an important part. It is certainly true that all states with nuclear arsenals are planning for their maintenance and modernization. In the United States, about $1 trillion is projected to be spent over the next 3 decades on maintaining and upgrading nuclear forces. And it's estimated that every year around the world, $100 billion is spent by all the countries on maintaining their nuclear arsenals and related programs. However, there is an awareness that it's a very serious problem, this ongoing reliance on nuclear weapons. And I think something encouraging, which maybe isn't getting enough attention, is that the recent agreement with Iran on limiting its nuclear program so the world can be sure that it's not acquiring nuclear weapons, that first of all strengthens the non-proliferation regime aimed at preventing the spread of nuclear weapons. But it also demonstrates that it is possible to negotiate binding legal arrangements that involve verification, that have timelines. And so I think that the world should be saying, let's do the same thing on the reduction and elimination of existing nuclear arsenals, because they're a problem too. Mm-hmm. Not only that states might acquire them or terrorists not acquire them. As the UN Secretary General says, there are no right hands for the wrong weapons.
Okay, so I would like to take that and just veer to the side a little bit. One of the problems is a lot of people just can't get the concept of nuclear weapons around their head. You don't see people marching in the streets so much these days. How do you think it's possible to frame this topic in a way that engages the general public?
I'd be famous if I had an answer to that. People who work on this problem, governments generally, they know it's a very serious problem, but it does seem like the urgency, especially in the United States, has been lost.
What got you in the streets these decades ago around Livermore? What got you protesting, and what was the kernel?
Well, it just seemed unacceptable to me that there was a risk of cities around the world going up in flames, and it still seems unacceptable to me. I think one of the problems may be that people have grown used to nuclear weapons. They're sort of part of the landscape. Mm-hmm. They're like the furniture in the room. Mm-hmm. Another problem is people might think, yeah, a nuclear weapon-free world is a good idea, but it's sort of beyond my ability to influence that. But I think one thing that we have been trying to do is to make the connections between the struggle to protect the climate and the struggle for nuclear disarmament. Mm-hmm. And the Marshall Islands is really instructive in this regard, because Tony DeBruym, the foreign minister of the Marshall Islands, has been quite prominent in the discussions over the last 2 years or so about the agreement that they will start negotiating in a few days, November 30th, in Paris, the new climate agreement. Mm-hmm. Tony DeBruym says, well, we have to save our islands, we have to save the world from global warming, But what good will that do us if the world goes up in flames from nuclear weapons? So they're both existential threats, and they both involve planetary political and legal processes. And so I'm hoping that people realize that something can be done on both fronts.
Okay, and then the final question, do you think there'll be abolition in your lifetime?
Yes.
Okay. Well, on that very positive note, we thank you very much for joining us. And we thank you also for the amazing work that you have done for so many years in this area. And we thank you for joining us as well.